Please welcome Andy Schlafly.
Thank you, Larry, and thanks to all of you for being here. We don't start this early in court. Court doesn't start till 9:30, 10 o'clock. I mean, try to gather my thoughts here and see how to wake everybody up. Reminds me of picking a jury. And at one of our AAPS conventions, we actually did a mock jury selection. It was a lot of fun. Some of you may remember that. I remember you were there, Tamsin. And we had interesting effort picking a jury among AAPS attendees. And maybe we should do something like that this morning. I want it to be more interactive. Let me start with this question. And you're not, generally when you pick a jury, you don't get into politics. You can't get into religion at all. But you can get into politics a little bit because you don't want any bias among your jurors. But I think everyone here heard Ted Cruz's speech yesterday. And Ted Cruz said something, and I was sitting there and I thought, that's a little unusual for Ted Cruz to say that. And he came on pretty hard against somebody else in his speech, and I'm thinking, I haven't heard any of the candidates do that. And I put two and two together, and I realized something after Ted Cruz's speech, that there's something that may be happening in the Republican nominating process that has not been widely reported yet. And can anybody here think of what that is that may be going on behind the scenes that Ted Cruz had some clues of? There it is, right there, John Eck. Romney, Mitt Romney. So you want to elaborate on that a little bit, John? What's going on? Okay, they can't hear you, so I'll repeat it. But Ted Cruz went hard against Mitt Romney in his speech. And I'm thinking, well, I was sitting there listening, go, that's a little unusual. I mean, wouldn't Ted Cruz want Romney to endorse him? And, you know, Romney is not a candidate in the race. Romney's thinking about getting in. And evidently Ted Cruz is concerned enough about Mitt Romney jumping into the race that Ted Cruz is starting to develop the arguments to criticize Mitt Romney and starting to attack Mitt Romney before Romney even jumps in, because evidently that's going on behind the scenes, that Mitt Romney is thinking about getting into this race. And wouldn't that be something to see Donald Trump, who tries to be politically incorrect, debate Mitt Romney, who tries to be politically correct? That would be hilarious, wouldn't it? The severely conservative Mitt Romney coming in, and the thing they have in common, though, Trump and Romney, is they both support single payer or have said good things about it. Now, they'll never admit that, and if you try to pin them down on it, they say, no, not really, but they both believe in everybody being insured. And so does Chief Justice John Roberts. And that's what we ran up against in our Obamacare litigation, is that Chief Justice John Roberts is a true believer in the whole mentality behind Obamacare. And John Roberts, if you study him and psychoanalyze him and read his writings and so on, he's like just smart enough to be dangerous. He's like, you know, he's just smart enough that you sort of feed him certain ideas, and if he sort of latches onto it, it's like a dog grabbing a biscuit, biting a biscuit, and he won't let go. And he has fallen for the fallacy of universal coverage, of trying to make everybody insured. He thinks that that is a goal of itself, that if everyone were insured, that would be success. Then we would be at the finish line and we would have what we want, universal insurance. But that doesn't mean people are getting the care they need. That doesn't mean that their money is well spent. That doesn't mean it's better than a free market system. So if you read his opinions, and he's done it to us twice now on Obamacare, you read his decisions, he thinks universal coverage is the goal. And Obamacare is a step towards that goal. He praised Romney Care in his recent decision, that how it reduced the number of uninsureds in Massachusetts. But he didn't point out or observe that it also increased the waiting times in Massachusetts. And if you really need medical help in Massachusetts, you got to wait a long time to see a doctor. And that is certainly not a good thing. So, unfortunately, there are 5 votes there on the Supreme Court to continue to uphold Obamacare against legal challenges, but at AAPS, we don't quit. We're not stopping. And there's one challenge, there's one challenge that the Supreme Court hasn't addressed yet, and that is how Obamacare violates the Constitution with respect to the origination clause. Obamacare originated in the Senate, and the U.S. Constitution, Article 1, Section 7, says if you're going to raise taxes, raise revenue, it's got to originate in the House. Those cases, we're still pushing them along, and in the next term, we're going to push those cases up to the Supreme Court and try to get the Supreme Court to address how Obamacare was enacted in violation of Article 1, Section 7 of the U.S. Constitution. And John Roberts has a reputation of defending the Constitution, and despite of how he's fallen for Obamacare, and despite how he thinks universal coverage is the goal, he still needs to address how this was enacted in violation of the U.S. Constitution. So we're going to push that approach here, and we will keep at it. And who knows? Nobody thought that Speaker Boehner would be resigning after 10 months into his term as Speaker of the House, right? And who knows? Maybe the U.S. Supreme Court will wake up and say, maybe we should follow the U.S. Constitution with respect to Obamacare and get rid of this monstrosity. And in the meantime, we hope to educate Chief Justice Roberts and others on the court about how the fallacy of universal coverage being the goal. The goal is for people to have access to medical care as they need it. That is the goal. And the goal is for people to be able to spend their money to buy goods and services that people want to buy for themselves, rather than have something imposed upon them that forces them to buy something that they don't want. Chief Justice Roberts has never addressed that. Of course, you can get universal coverage by forcing people to buy a product they don't want. That's easy to do. But what you want is a situation where people can buy the goods and services that they really need. Okay, I'll digress a little bit to talk about my classmate, Barack Obama. We're getting near the end of his term as president, and then this. And then there will be, it won't be such an interesting discussion because he will then drop into the memory hole and people will move on. And he's not too happy about that, I can tell you. Knowing him at law school, he is someone who likes the attention, and he's not a happy camper that attention is disappearing. And it's interesting because it plays into the 2016 election, and that Barack Obama is not going to be helping any of the Democratic candidates for president because it dims his own star. It takes attention away from him. And unfortunately, he's that self-centered that he doesn't want the spotlight to be on anybody else. He wants to be the center of all the discussion, and he wants his presidency to stand above the presidency of anybody else, and that means he really doesn't want Hillary to be elected. He really doesn't want Biden to be elected. Honestly, he'd probably be just fine with Mitt Romney being elected, because he can say, I beat Romney, and nobody else on my side could beat him. So that's the problem the Democrats really are dealing with. They're not going to get the cooperation of the president of their own party as they try to win in 2016. So I don't know if the Republicans can affirmatively play off that in any way, but it's going to help. There's nothing Republicans really need to do. The Democrats are going to fight among themselves, and they've got that problem with the leadership there that is going to make it harder for them to win the presidency. All right. Let me talk about judicial supremacy a little bit. One of the advantages of doing the closing to a jury is that you get to speak last, and you get to speak after the other people speak. And yesterday in some of the discussions, I don't know that anyone really came to grips with the problem of judicial supremacy that is an increasing issue, and how the U.S. Supreme Court is doing whatever it wants without regard to the other branches of government. And there's an expression that you'll hear most attorneys use, and a lot of lay people use, and a lot of the presidential candidates use, that is a sign that they're a judicial supremacist, which means that they believe that the courts are greater in power than all other branches of government. And it's not. The courts are just one of three branches of government at the federal level, and the same is true at the state level. And the founders actually described the federal judiciary as the least dangerous branch. Well, that seems anachronistic today, doesn't it? We've got a Congress that is so ineffective, and Congress sits around waiting for the Supreme Court to rule on issues. That wasn't the way it was when our country was established. But judicial supremacists believe in that. They believe that the courts are above the other two branches of government. And the phrase that they use, that you can watch for, is when they talk about the Supreme Court establishing the law of the land. Watch out for that when you hear a candidate use that expression. Attorneys will use it. We all get this in law school. It's very difficult to meet an attorney who doesn't believe this, because we're all taught this, that the Supreme Court establishes the law of the land. And I got some of that flavor yesterday in one of the talks, that we have to, you know, the attorney was sort of saying, the court's going to do this, the court's going to do that, and we have to go along with that, and we just sort of hope and pray that the court will, you know, eventually rule in our favor on something. That's not the way the system's supposed to work. The Supreme Court does not establish the law of the land. Congress establishes the law of the land. And we need a candidate who recognizes that. We need all the candidates to recognize that, and Trump's making that mistake. Trump will talk about the Supreme Court establishing the law of the land. No. And what we need to remind everybody is that the Supreme Court, or any court, cannot enforce its own rulings, has no power of the purse. These belong to the other branches of government. Congress funds the enforcement of court orders. Congress has the power of the purse. It can cut off the funding for anything that Congress wants to cut off the funding for. Congress can cut off the funding of Obamacare. It has that power. Congress can cut off the funding of court orders. Congress can withdraw jurisdiction from the courts. The president, the next president, can issue an executive order that declines to enforce Supreme Court rulings on Obamacare or anything else. This is the way the three branches are supposed to interact. So we need to get closer back to that. That's where we were. And there have been numerous presidents over the years who have said that. I mean, Andrew Jackson stood up against a Supreme Court decision. And he said, okay, the Chief Justice has decided, now let him enforce it. Chief Justice cannot enforce anything. And what Jackson was saying, that he's not going to enforce the ruling that he felt the court overstepped its power. Abraham Lincoln and other presidents done the same thing. Jefferson, go back and read the writings of Jefferson on this issue. Thomas Jefferson thought the courts were the biggest threat to our liberty in the new country. And Thomas Jefferson, believe it or not, in one of his writings, he actually said that if these federal courts get out of control, as I fear they will, the country may have to split up. That's what Thomas Jefferson wrote. You're not going to hear that in any schools. You're not going to read that in the history books. No attorney has ever learned that in law school. But that was how fearful Thomas Jefferson was of the federal judiciary getting out of control. So when I'm in court, I prefer to be in front of a jury. Because jurors, you get to pick your jury to some extent. You get to exercise peremptory challenges. You get to excuse jurors for bias. And think about what kind of a jury would you want in some of these cases. Imagine if we had a jury sit in judgment on Obamacare rather than the judges. And we had some control over which jurors we picked, and we could eliminate jurors for bias. We may have gotten a very different decision out of a jury on Obamacare. Talk about some of the projects we're doing at AAPS to stand up for private medicine and protect it against the many enemies that are assailing it from all sides. And it's a long list, isn't it? Hospitals that are assailing practice of private medicine. Why do hospitals have tax exemption when they're paying their executives so much money, when they're run like businesses now? Well, there's a court that recently took away a hospital's tax exemption at the state level. There's a step in the right direction. Maybe we should get involved in that and try to take away the tax exemption for all these hospitals and build a movement on that. It's incredible to see hospitals in some of the litigation that I'm handling for AAPS and AAPS members and so on, see hospitals come into court and say with a straight face that courts should defer to hospitals and not have any judicial review of the decisions made by hospitals with respect to medical staff privileges and so on, and say that with a straight face. I mean, I didn't see hospitals mentioned anywhere in the Constitution as a fourth branch of government that's above the other ones. And yet they make that argument. And there are still a few states, not many, there's still a few states where the courts actually refuse to get involved in decisions by hospitals concerning staffing, medical staff privileges, reporting to the data bank, and so on. It's down to only 3 states that are like that: Iowa, Oklahoma, and South Carolina. All the other states, over time, have recognized that hospitals are not above the law. Hospitals can discriminate. Hospitals can do all sorts of improper things. And so in the other 47 states, courts will review hospital decisions and are increasingly doing so. And on behalf of an AAPS member, I have had a federal injunction in place against the hospital for 3 years now, more than 3 years, that forbids the hospital from reporting something to the National Practitioner Data Bank. And we're going to continue to do more of that. Go into court and get injunctions against these hospitals as they think they're above the law and as they try to destroy doctors using the data bank. Do you know how many entries there are in the data bank that smear a doctor and other medical practitioners? Take a guess of how many data bank entries there are in there at this time against people, as almost always initiated by hospitals, although insurance companies are starting to get into this act too, and they will initiate some of these data bank entries. What do you think, maybe 10,000, 50,000, 200,000, 800,000. 800,000 entries in the data bank to try to hurt a doctor or other medical practitioner. Yeah, when did that start? When did that data bank start? 1986, part of the Healthcare Quality Immunity Act. One of those great ideas that came out of Washington, D.C., I'm being sarcastic, that said, we'll establish a national repository of information to stop those evil doctors who hurt somebody in one state and then run to another state and try to hurt somebody there, and then run to a third state and try to hurt somebody there. Have you ever met a doctor like that who tries to go around different states and hurt people? I mean, not very many of them, that's for sure. They're not 800,000 of them. So Big Brother decides they're going to do a database and hurt the profession that way. And there are other databases that we need to wake up to. And AAPS is fighting other databases. There's 16 states that have a law requiring health insurance companies to send over their medical claim data so that the state can build a huge database of medical record information. And supposedly, states say we're going to do this because we're going to see the inefficiencies in the delivery of medical care, and we're going to identify those, improve those. All right, so Vermont's doing this. And this case is before the US Supreme Court because some small health insurance company objected to it and said, no, we're not going to send you that stuff. And that has taken up to the US Supreme Court. And with your support, we filed an amicus brief to oppose this collection of medical record information about patients by states. And one of the things I said in the brief, I said, yeah, states say they're doing this because they want to identify unnecessary procedures and stuff, and here's an example they give of an unnecessary procedure. Well, I went on the internet, and I found out that 20 years ago, this procedure had been identified as overused. And you can turn on CNN, and they were talking about this 20 years ago. You get the state saying they need a database so they can get this great revelation that one of these procedures is overused. You're not going to learn anything from these databases, anything useful. What you're doing, what these states are doing is they're monitoring, starting to control. It's a step towards single payer. That's what it is, where states get control of this. And it's a complete violation of the patient-physician confidential relationship. States say, oh, we de-identify this information. You can't tell who they are. Okay, so I did some research on that. And turns out some scholars somewhere looked into this de-identification of healthcare information, and they found it's fairly easy to re-identify the patients after the data has been de-identified. And in fact, they took some de-identified information from up in Massachusetts, and they re-identified that one of the patients was almost certainly the Governor William Weld of the state of Massachusetts. And that all you need is someone's birth date, zip code, and maybe something else in the medical record, and you can re-identify with a high degree of certainty who that person is. So the Supreme Court has that information. And let's hope they understand the value of confidentiality. Because there's Supreme Court justices, of course, who have their own health issues. And maybe they wouldn't like their own health information on the front page of the Washington Post or New York Times. I imagine they wouldn't. And I said in our brief, by the way, many presidents throughout history have been very secretive of their medical record information. So if the presidents are allowed to keep their information confidential, why are people in the executive branch running around and grabbing other people's medical records? And I went through the list, and it's actually a longer list than I realized of presidents who had hid health problems from the public. President Woodrow Wilson, apparently for his last year or so in office, he was stroked out and couldn't even do anything. And the public didn't know that, and even his cabinet didn't know that he was basically incapacitated. And the country was running on autopilot, and those records were kept confidential. Of course, FDR ran for re-election and then died of some illness shortly after he was re-elected. Maybe it was 5 or 6 months. I think he was re-elected in November, and he died in March. And to this day, I'm not sure anyone really knows what he died from. There's some speculation. One AAPS member speculated it's melanoma based on pictures of him, right? Based on pictures of him, she sees something above his eyebrow, but it's never been fully disclosed. Our current president, what do we get on his medical records? We get his doctor releasing a couple sentences that says, well, he's in excellent health. That's all we get. Well, we got involved in another case where evidently the executive branch of our federal government is writing administrative subpoenas for itself with no judicial review, and they show up at a doctor's office, knock on the door, say, here's an administrative subpoena, turn over your patient's medical records. And the doctors look at it and say, well, aren't you supposed to have a warrant for this? I mean, aren't you supposed to have some judge sign off on this? No. No, the federal government is asserting the power based on merely an administrative subpoena that they write for themselves, that some agent just simply drafts it up, the word processor prints it out and signs it. The agent, the investigator himself. And they claim the power to seize all your patient's medical records. That's shocking to many of us. And they're doing this hundreds of times. And they did this in Texas, and a doctor objected to it. And I'm not going to turn it over. And it got into litigation. It's going up before the Fifth Circuit. And again, with your support, we have filed an amicus brief on the side of the doctor and on the side of the patient-physician relationship. Look, if you need to get this, there's something called the Fourth Amendment. You go to a judge, you explain what your reason for it is, the judge reviews it independently. If he agrees, he gives you a search warrant. All right? It's the same rule that's worked for over 200 years in this country for everything else. Okay? The government cannot search the trunk of your car unless they have a search warrant in most cases. They certainly cannot come into your home without your consent unless they have a search warrant. And even if they have a search warrant, they're only allowed to look in the areas that the search warrant specifies. Okay, so if you're sitting at home and you get a knock on the door and there's some agents outside and they say, we're going to come in and look around. You say, no, I don't think so. Do you have a search warrant? No, we don't have a search warrant. Okay, well, see you later. You're not coming in. Go run along now. Okay. Then they come back. They say, we have a search warrant this time. I say, okay, show it to me. Show me the search warrant. They show it to you. Make sure it's signed by a judge. Make sure it's a signed search warrant. Look at the areas that it authorizes the agent to search. It's not going to say he can search everywhere. It's going to say he can search your office or something. Okay, the search warrant says he can search. That's the only area he can search. Okay, videotape it. So you videotape where these agents go, and they're limited to what the search warrant says. Okay, but with these administrative subpoenas, they come to your medical office. I'm not talking about your home now. And they insist these sweeping powers have not been reviewed by a judge. No independent verification. And they grab patient records, and in this case, they tell the doctor, don't tell the patient. Don't tell the patient. We're grabbing his records. That is complete invasion of our Fourth Amendment rights, of the patient's Fourth Amendment rights. And as physicians, we need to stand up for those rights and defend them. And this is the front line of defense of private medicine, is to protect that patient-physician relationship so the government does not take that relationship over. So as long as we can keep that protected against government interference, we'll be in pretty good shape. So we're waiting for a decision on that case. Talk about MOC a little bit. AAPS has been the leader in fighting against maintenance of certification, where you have these private, unaccountable groups, the ABIM, it's a whole alphabet soup of these groups, there are 24 of them. The umbrella group is the ABMS, where they are in this money-making scheme causing doctors to jump through all these hoops to get recertified, or else the doctors lose their medical staff privileges, they get kicked off insurance plans, a whole laundry list of things occur. There was a push for maintenance of licensure. You heard about that yesterday. We've been able to stop that, and we're starting to roll back MOC too. And as you can see, a lot of these specialty societies are starting to retreat on MOC, but we're going to continue to chase them until they abandon it. So yesterday our board of directors met, and we'll meet again on Saturday afternoon, and anyone here is welcome to attend our board of directors meetings. And our board approved an additional lawsuit. We have one existing against the ABMS based on antitrust law, because we say this is anti-competitive restraint of trade, what these specialty societies are doing. And we're going to file a new lawsuit, and this time it's going to be against the American Board of Internal Medicine, and this time we're going to point out how discriminatory the MOC is. And we will see how the ABIM explains the way that it discriminates based on age. It says older people don't have to do it, but younger people do have to do it, which discrimination on age is unlawful in most areas of the country. There's evidence that it discriminates in other ways too, and we're going to file suit against the ABIM, and we're going to force them to explain themselves and try to justify. And that'll be interesting, and maybe we'll, as part of our discovery in this lawsuit, we'll do some digging into that multi-million-dollar condo that they purchased in Philadelphia. I was wondering if they were going to host the Pope there at their condo. Why not put that thing to good use? And by the way, why do these specialty societies have tax exemption status? I mean, it's just a business. I mean, they're not fooling anybody. It's just a business. Why are they tax exempt? paying themselves these astronomical salaries and so on, they shouldn't be tax exempt. All right. Before we get into some questions here, I want to mention insurance companies just briefly and the whole out-of-network issue. And I met with some physicians about a week ago, and they talked about how there's legislation being pushed in a lot of states to limit out-of-network billing. And at first, the physicians thought that maybe that's okay. Maybe that's okay. They said, some of these physicians felt, well, you don't want these doctors who are out of network with insurance companies, some are in network, some are out of network. And the doctors said, well, some of these out-of-network bills, based on what we've read in the newspaper, maybe there should be some limits on how much someone can bill out of network. And it just took me a couple sentences to turn the doctors around and convince them that you don't want any price controls on out-of-network billing. Because once you get price controls on out-of-network billing, then every doctor loses his leverage with insurance companies for all billing. All the in-network doctors will lose their leverage with insurance companies on in-network rates once insurance companies succeed in price controls for out-of-network rates. Because the leverage that every physician in this room has in dealing with insurance companies is the option to go out-of-network and start to bill free market rates. If you lose that leverage, as I explained to these physicians, then all the insurance companies have to do is start to reduce in-network rates, and there's nowhere any doctor can go. You're stuck. And at that point, if insurance companies are able to eliminate the out-of-network rates, or price control out-of-network rates, then insurance companies will just continue to drive rates down further and further with doctors not able to do anything about it. Right now, where there's out-of-network billing, every doctor can leave the insurance network, go out-of-network, and start to bill insurance companies on an out-of-network basis. And I encourage everyone in this room to consider doing that, to go out-of-network. And I've handled a case for an AAPS member where he was working in a hospital and he was out-of-network. He did the services, he billed the insurance company the out-of-network rate, and we sued, we took it to a jury. The insurance company thought they were going to win this before a jury. They thought they were going to try to portray the doctor as charging too much or somehow being greedy or whatever. We took this to a jury. We explained what was going on. He did the services. Insurance company got the benefit of the services. They promised to cover the patient. The insurance company should pay their bills. What happens if you or I don't pay our bills? Okay, what happens if we don't pay our cable bill? They turn off the football games. What happens when the insurance companies don't pay their bills? They hire some expensive expert consultant from Washington, D.C. to come in and say, oh, I've studied all the data and these bills are too high, and they don't have to pay. It's outrageous. Explain that to a jury, and they understand. They understand. So we need to take more of these cases to a jury. And I want to leave some time for questions, but let me just close with this. AAPS members are special, and I enjoy helping all of you on any issue you have. And nice thing about AAPS members is you're willing to fight. You're willing to stand up and fight against the system, and we're the only ones who fight against the system. Everyone else, when these lawsuits with insurance companies against doctors, every other doctor and his attorney caved in, except for the AAPS member. Everybody else caved in. They start to get closer to jury trial. Everybody gets nervous. Everybody starts breaking out a sweat. Not an AAPS member. So we stand up and fight. And with your help, we will continue to stand up and fight and save private medicine. Thank you very much.
Andy, just a couple questions.
Yeah.
In the case of Morristown, where they found against the hospital.
Yes, they did.
And the mayor said that, yes, you owe back taxes.
Yes, yes, they did.
In that case, are there any other pending, do you know of any other pending cases in New Jersey where there are other hospitals that are going to be similar? Because that hospital CEO made $62 million in 1963, or 2013, excuse me, 2013. The second question I had was with regards to the ABIM. You know, it said this, justice delayed is justice denied. Or how long can they just defer this before they have to bring this to trial?
I think you're referring to the ABMS case. That's our antitrust case, and cases will sit for a while, but then the way the process works in the judiciary is sort of the oldest case in the docket then suddenly gets a lot of attention, then it moves very quickly. So I think our antitrust lawsuit will start to move very quickly as it becomes one of the older cases on the docket. We're not waiting though, and we're going to bring this new case against the ABIM, and we're going to keep chasing them. So you can see MOC is on the retreat, and we're just going to keep chasing until we get the job done.
Andy, there are some new board certifying entities, National Board of Physicians and Surgeons, and for hospitals or insurance networks that have in their policy statements that their network physicians or hospital staff members have to be board certified by the ABMS, is there now a case for antitrust or discrimination against other board certifying agencies?
We talked about that at the AAPS board meeting yesterday, and we're looking for a physician who runs into that issue, who has board certification with another group, and the hospital doesn't recognize it. There are about a dozen hospitals that recognize the other board certifying group. And so we want a case. I'm not aware of any cases that are out there yet, but we want to hear from a doctor who's board certified by the other group, who then finds that his privileges are lost because of that, and we'll take that up. Yes.
I came here, Medicare's been chasing me for about a year because I do complementary and alternative medicine, and my attorney says I should come to this meeting. And before I came, I had figured out a way how to kill the beast, and one of my patients, who's very religious, said that you can only kill darkness with light. You can only kill evil with truth and light. So in my mind, I came up with this idea that healthcare has basically, well, the AMA has basically dehumanized our patients. And then they basically turned them into ghosts and then cash cows. You have to go back to what is true and what's not true. And what is true is there's a lot of not truths in medicine, like knee replacement surgery is not true.
Okay, I get the point. That's a good point. And educating our patients is part of this process. And that's the one reason leftists attack the medical profession so much, is because they know that the patients listen to their doctor. So if we educate our patients more, we can accomplish a lot more.
Hey, Andy, is there any effort to go down the line of conflict of interest? If you look at Obamacare and MACRA with the boards that they are giving grants to look at our quality indicators and such, like NQF, which is Christine Castle, who was president of, or head of ABIM, and is now head of NQF. So these same people that our tax dollars are giving them grants to decide what our MOC and what we do, and then they make money from it.
Yes.
So to me, that is just a shocking conflict of interest from an ideologic and a financial standpoint.
Yes, that's an excellent point, Chris. There's a lot of federal money behind this, and there's federal money now behind the Interstate Medical Licensure Compact and the commission they're setting up, which we're going to sue to challenge that too, based on the Constitution, because Congress has not approved this Interstate Medical Licensure Compact. But we found there's federal money pouring in and channels through the Federation of State Medical Boards to try to set up an interstate commission to handle medical licensure. So we're on that issue. Yes.
My name is Michael from Pensacola.
Yeah.
As I understand it, the Supreme Court has declared Obamacare as a tax.
Yes.
I, as a private physician, am a strong advocate for the fair tax. I think we can actually get patients behind us, and indirectly, with Obamacare being a tax, if we were able to reform the tax code in the right way, then Obamacare essentially loses its supply line and could be repealed.
That's interesting. That's interesting. Repeal Obamacare by moving to a fair tax. Let me think about it. That's a clever idea. Thanks for suggesting it. Well, hold off. I'll talk to you afterwards. Let's move on. Well, let's hold on. Let's get someone else to speak, if that's all right. I'll speak to you afterwards. Go ahead. We got some hands over here.
Andy, Dave McCaleb, St. Pete, Florida. Thank you so much for all your great work. Yesterday we talked about the First Amendment, and we talked about doctors losing their rights to practice, asserting their natural right to free speech. But the converse of that is I feel that I'm being coerced into speech, that I'm being coerced into saying, and I don't do it, I just take the penalties. But if I were in this system,
Right.
I would waste time as a neurosurgeon talking about smoking cessation and alcohol,
Right.
and do their kids live close to a park and all this nonsense. Is there a way to go after coerced speech and then even bring it into a level of coercion in general when it comes to antitrust law and the exemptions that insurance had under McCarran-Ferguson and such?
There are some of those issues pending in the court system, coerced speech, and perhaps the most famous example of that is how they're getting doctors to ask about gun ownership and ask kids about whether their parents have guns. And I put this in our brief because if the federal government can come in with administrative subpoenas and not even have a warrant, they can come in and find out who owns guns just by going to the doctor's offices, grabbing all these records, and they find out who owns guns in the community. And for some people, that's a criminal offense to own a gun, and they can start locking people up by going through medical records. And so we need to stand against the coerced speech that's compelling doctors to ask these questions, and we need to protect against access to those records.
Just a quick question. There was things come out in the AAPS news about Medicare with Obamacare. We didn't have to opt out every 2 years. I don't
That's
know if
right.
I've understood that. Could you
That's
please
right.
just briefly touch on that?
Yeah,
Thank you.
after June 16th of this year, every opt-out affidavit is effective permanently without having to re-opt out. So if you opted out before June 16th of this year, you still have to opt out one more time when your 2-year cycle is up. But if you opted out after June 16th, you don't have to re-opt out again. You can come back in on every 2-year cycle. You can go back into Medicare. Not many doctors want to do that. Okay, next.
Is there, if I remember correctly, this might need a constitutional amendment, but some states have recalled judges that made really stupid calls judicially.
Yes.
How hard would it be to do so we can recall Supreme Court judges?
Unfortunately, that would require a constitutional amendment to do that. And this is what Thomas Jefferson wrote about it, and I urge everyone to take a look at what he wrote. He said, this is crazy. Give these judges life tenure, you can't recall them, you can't impeach them. And that's something we should think about. Getting your congressmen to start thinking about impeaching federal judges. It's been done. It's been done for abuse of the contempt power. It's been done for a variety of reasons, not in recent history. But Gerald Ford tried to impeach a Supreme Court justice. Gerald Ford, not necessarily the strongest conservative in the world, but so they were doing this a generation ago, and we got to get some of our congressmen today doing this.
Okay, we'll take a couple more questions here.
Thank you, Andy. Hans Lessman, Pittsburgh. Thank you for all you do. God bless you for your work. As a strategy against the progressive movement, I mean, we're playing defense here a lot of times.
Yeah.
The progressives are playing offense.
Yeah.
Okay, what can we do in an offensive way or a proactive way? I don't quite have any good ideas, but just bringing up as a strategy to promote private practice
Yeah.
medicine, take an offensive position.
I think the offensive way is try to get out of Medicare, get out of the insurance networks, go cash as much as possible. That's what we're doing on the offense, and we have many seminars on that. A lot of our regional conferences do that. That's the offensive move. Just get out of the grip of insurance companies. You heard, even Senator Cruz noticed how the insurance industry is consolidating. He's aware of it, and of course everyone in this room is aware of it. We're going to end up with one insurance company, and then it's going to go single payer. We've got to get out of those networks. Yeah.
Hi, I was just wondering if you could touch a little bit on the House case that was approved about a month ago, where they're essentially trying to argue that the money that the federal government is using for subsidies has not been authorized. I was wondering if you could compare that to the other cases that have been at the court and where you see that going in the future.
Yeah, I mean, unfortunately, the court upheld the subsidies in King versus Burwell, and it was John Roberts writing the decision again. So even though the law says that those federal subsidies should not be flowing in states where the federal government set up the exchanges, those subsidies, according to the law, according to Obamacare, should only flow where the states set up the exchanges. But most states refuse to set up an exchange. And they just got around the law, and the Supreme Court upheld it. And the problem is, John Roberts is a true believer in the basic approach of Obamacare, which is universal insurance.
Andy, thank you for everything you do. I have a comment on the silent PPOs or the hidden PPOs. Could you make a comment as to what these are they legal, and what can we do about them?
I think you have to look at the details of it, of what is actually going on. Can you explain a little more of the detail
I
that
think
you're
they
talking
also
about?
go under the name of rental PPOs.
And to the extent that insurance companies are controlling them, or is this doctor initiated? If it's doctor initiated, I think it's something worth looking at. If it's insurance company initiated, then it's not going to be good for doctors.
It's actually for the doctors who are not, who are out of network.
Okay, so it's doctor initiated then.
Yes.
Yeah, well, it should be legal. Now, you will hear insurance company types try to scare doctors and say, oh, you can't organize, it's going to violate antitrust law. But go ahead and explore those types of networks, and it's not necessarily a violation of antitrust law for doctors to form their own networks, and it can be helpful in providing doctors some leverage to oppose all the conspiratorial activity that's going on the other side against doctors.
Okay, I think we have time for one more question here.
Thank you. I want to catch on what was said here before. What are we doing, or what is this organization doing about the concentration of healthcare insurance? For example, Nevada in Clark County, which is Las Vegas, over 90% is United Healthcare, and this came in front of a judge a couple years ago, and the judge let it happen. In California, Blue Cross is it, pretty much. They seem to consolidate on a silent agreement in certain states, and there's nothing physicians can do against it that I have been aware. You basically are confronted with the huge insurance company that holds all the contracts, and there's not even competition anymore.
That's right. That's a huge problem. That's a step towards single payer. And first step is for doctors to get out of insurance altogether. Don't sign their contracts if you can. And a lot of AAPS members are doing that. So that's a step you can do on the personal level. In terms of policy, we can object to these mergers. And in fact, these insurance companies are starting to merge with hospitals now. Have you seen that too? Where, yes, in some areas of the country, insurance companies are saying, if you're insured by us, then you have to go to this hospital. And we're starting to get a grassroots opposition to that. So we need to educate the public and get the public and state legislators to pass laws that prohibit this. Okay, thank you very much.